Thank you. Thank you very much.
It's Ivy Technical Community College and Miss HIVELY. And you can see Ivy Community College there on your left, making Indiana great again. And over here is Miss HIVELY, Kimberly HIVELY. Now, Kimberly HIVELY was a professor, an adjunct professor at Ivy. And she'd been there for 14 years. Good professor, no complaints about her performance, all this kind of stuff, doing a great job. Now, an adjunct, for those of you not really into the college scene there, an adjunct is somebody who has a full-time job, usually somewhere else, doing something else. And then they come in and they teach at the college, and most colleges have adjunct professors. Now, a lot of adjunct professors love being adjunct professors. However, Miss HIVELY wanted to become a full-time associate professor. And the reasons for that are pretty simple. First of all, you get benefits. That's nice. Second, it's a full-time job. She had always been turned down, every single time. And we're talking 6 times, all right? And eventually they fired her. Well, this makes a pretty easy case to make, because when she said, hey, asked, how come I'm being turned down all these times for these jobs? And how come you just fired me? And they said, well, you're a lesbian. Okay. So that makes the case pretty simple. So Ms. HIVELY wasn't going to take that. So what did she do? She sued. There you get the name HIVELY versus Ivy Technical Community College. Okay. Well, she's basing her case on an EEOC decision that was decided June 15th, 2015. And the EEOC, on their own, came out in a case called Baldwin versus Fox, and said, from now on, we are going to treat sexual orientation as a protected class. Now, those of you that aren't real familiar with protected classes, Title VII, Age Discrimination Act, pregnancy, ADA, all these different civil rights laws give protected class status to certain classes of people. Like you can't go up to somebody and fire them because they're 70 years old. You can't fire someone because they're Muslim. You can't fire somebody because they're black. You can't demote somebody because they're white. You know, those are protected classes. Well, under Title VII, traditionally, the Title VII of the 1964 Civil Rights Act, that has traditionally excluded sexual orientation as being a protected class. Title VII of the 1964 Civil Rights Act protects sex. You can't fire someone because they're male or female. Now, Ms. HIVELY here is saying, well, the EEOC last year said sexual orientation is inherently a sex-based consideration. And therefore, if you fire someone because of their sexual orientation, that is sex discrimination. I mean, basically, here's her argument. Is I'm a woman. To be a lesbian, you have to be a woman. And basically, lesbians love other women. Ergo, sex discrimination. Well, the federal district court found against Ms. HIVELY. So what did Ms. HIVELY do? She appealed, and she appealed up to the 7th District Court of Appeals. Unfortunately for Ms. HIVELY, she lost. Now, this was a typical case before the 7th Circuit Court of Appeals, and it was a 3-judge panel. Judge Rovner wrote the decision for this case, and she was very sympathetic towards Ms. HIVELY, very sympathetic. But she's saying precedent is very strict here. Title VII never meant to cover sexual orientation. That is not what Congress intended. And for those of you that are watching the courts more closely now, which you should be, you realize that there are judges that believe it's okay to interpret language from Congress. There are other judges, such as the late Justice Scalia from the United States Supreme Court and his predecessor, Judge Gorsuch, don't believe that. They believe you stick strictly to what Congress passed and nothing else. So it's the interpretation of judges. So if you've ever heard somebody say judges don't make law, you should wake them up, because that happens all the time. Now, in her majority decision, Judge Rovner listed several circuit courts that have specifically ruled sexual orientation is not sex discrimination, so it's not protected. The 1st, 2nd, 3rd, 4th, 5th, 6th, 8th, 10th, and the DC circuits, there is no shortage of courts that have ruled against Miss HIVELY on this matter. Now, the court also came back and they said Congress has repeatedly rejected legislation that would give protected class status to sexual orientation, that would extend Title VII to cover it. They've never done that. They've never done that. So the court basically said the only bodies that would have the power to give protected class status to sexual orientation would be the Supreme Court itself, because it could overrule all these circuit courts, or Congress. And Judge Rovner said, look, I'm kind of tied to the precedent here. I don't have any choice but to hold against you. Now, Judge Rovner did make a few very interesting insights here, and she's very sympathetic to Miss HIVELY. Because really, look at this. She was a good professor. Miss HIVELY was a good professor. She was doing a good job. There were no complaints about her performance. She had one fatal flaw. She's a lesbian. No, there you go. Now, it doesn't really matter what your moral compass should say here. The law is saying it doesn't protect sexual orientation. Now, think about this. There is a big push in this country to say that isn't fair. That isn't fair. Well, I got news for you, folks. Fair is where you show pigs. Fair doesn't have anything to do with the law. And that's what Judge Rovner is saying here. So she comes back and she says, the Supreme Court did expand sex discrimination back in 1989 in the case of Price Waterhouse versus Hopkins. Now, in that case, you had Ann Hopkins, and you're just going to love this case. I mean, you got to go back to 1989, which I realize some of you weren't even born yet. But those of us that were heavy into HR and law by then, this just blew the doors off you. Ann Hopkins was a top performer. Basically, she was a great performer. And let's take a look at her. She's a great performer. She is a rainmaker. She does a great job. But she's not the most feminine person in the world. So meet Ann Hopkins. Made civil rights history. Now remember, she is an up-and-comer. She is a great CPA. Now, when you're a guy and you're real aggressive, they say, oh, he's aggressive. He's an up-and-comer. When you're a female and you're an up-and-comer, we have a word for you that rhymes with witch. Well, they want to help her out. They want to help her out. So Price Waterhouse goes up to Miss Hopkins and says, you know, we're going to help you out. We're going to help you put on, some makeup. You got to wear some makeup, okay? And we got to get rid of those glasses, okay? We got to get you something that, a little more effeminate. We'll send you to charm school where they show you how to dress and they'll fix your hair. We just got to woman you up some because, you're a little too manly here for us, Ann. Okay, now you're listening to this with 21st century ears. This is 1989. And when she did not woman herself up, whatever that means, she did not get promoted. So she sued. And it went all the way to the United States Supreme Court, and the United States Supreme Court said, you can't tell women or men how they should dress, how they should act. That is gender stereotyping. That is gender stereotyping. And that means you can't tell men they have to act like this, and you can't tell women they have to act like this, because that is a type of sex discrimination. So look what the judge is saying here. This is the type of thing that should be decided by the United States Supreme Court. But it does give us a real dichotomy in the law. Here is Kimberly Hively. She's not protected. You know why she's not protected? Because she fits in with society. She isn't flamboyant. She isn't dressing like some wild person. So she is not protected by gender stereotyping. Now, RuPaul would be. Now, just get this, employers and HR folks and attorneys and whomever. RuPaul shows up, or somebody shows up dressing like who knows what. Guess what? That's protected. But Miss Hively steps in with her normal looks and everything because she is gay, because she is a lesbian. She has no protections. That is what we call a dichotomy. Judge Rovner then took a look at a few other types of things here. One of them, Obergefell. Obergefell we got back in 2015, and it basically says if you fly out to Massachusetts and get married, that you're gay and you get married, and then you fly back to Ohio or back to Indiana or something where they don't have same-sex marriage, the United States Supreme Court said you have to recognize that. It's unconstitutional. You can't say marriage is just between a man and a woman. That violates all kinds of clauses of the United States Supreme Court, including equal protection. So guess what? You can live in Indiana, work at Ivy Technical College, fly to Massachusetts, get married, come back to a same-sex partner, and then when they find out that you are gay, then they can fire you. Well, that doesn't make any sense, but that's the law. So, the Seventh Circuit Court of Appeals did find against Miss Hively, but they were very, very sympathetic about it. Well, on October 11th, 2016, the Seventh Circuit Court of Appeals agreed to rehear Miss Hively's case. So what's happening here is Miss Hively appeals not to the United States Supreme Court, but appeals back to the Seventh Circuit Court of Appeals, probably because Judge Rovner's opinion was so sympathetic. Basically, she thought maybe she could do better. But this time, the Seventh Circuit Court of Appeals, they appealed to all 11 judges. So this is what we call when the judges sit en banc, that all 11 are going to hear the case. So on November 30th, 2016, all 11th Circuit Court of Appeals judges heard oral arguments in Miss Hively's case. So we will call this Hively 2. Hively 1, she lost. So now we're looking at Hively 2. And in Hively 2, which was decided on April 4th, 2017, the Seventh Circuit Court of Appeals found for Miss Hively by an 8-3 margin. Now, what exactly is the reasoning here? Because understand, the Seventh Circuit reversed itself. So, Chief Judge Diane Wood wrote the opinion for the majority. And again, it was an 8-3 margin. So she wrote the opinion, and she said that the strongest point made by Miss Hively was the following. She wrote, Hively alleges that if she had been a man married to a woman, or living with a woman, or dating a woman, if she was a man, everything else stayed the same, Ivy wouldn't have refused to promote her, and they wouldn't have fired her. That is the basis of sex discrimination. Now that's a pretty good argument, isn't it? You're saying the only reason you're doing this is because I'm a woman. And 8 judges on the Seventh Circuit Court of Appeals bought it. Judge Wood then looked to Supreme Court cases and said that there is precedent for this from the United States Supreme Court. Judge Wood looked at the Price Waterhouse case in Ann Hopkins, which came up with gender stereotyping. Judge Wood also looked at the Oncal case, where Joseph Oncal was basically sexually harassed by and pretty much raped by his male co-workers out on an offshore oil rig. And the United States Supreme Court, in a 9-0 decision, by the way, said that it doesn't make any difference if the sex of the harasser is the same as the sex of the victim. Sexual harassment is sexual harassment is sexual harassment. And that gave us same-sex sexual harassment. She then looked at the case of Loving versus Virginia, which struck down Virginia's miscegenation statute, but it also came up with an association theory of discrimination, which means, look, if you happen to be white and you're hanging around black people and I fire you for that, that is discrimination on the basis of association. Or if I happen to be, healthy and I'm hanging around and helping people with HIV, you can't fire me for that because that is association discrimination. None of that was contemplated by Congress. So Judge Wood looks at several different types of cases, including Obergefell, as Judge Robner did. So in the end, Chief Judge Diane Wood wrote the majority opinion and found for Miss HIVELY. Now, not to be outdone by his fellow judge, Judge Joel Flom put his own concurring opinion in there. And what he wrote was also something to pay some attention to. He wrote, Ivy Tech allegedly refused to promote Professor HIVELY because she's a homosexual, or A, woman who is B, sexually attracted to women. Thus, the college allegedly discriminated against Professor HIVELY, at least in part, because of her sex. And Judge Flom writes, I conclude that Title VII, as its text provides, doesn't allow this. Why? Because she is a woman, and if she had been attracted to a man, that wouldn't have mattered. So it is based on gender. It is based on sex. Well, since the majority had its say, the dissenters have their say, and Judge Diane Sykes wrote the dissenting opinion for the dissenters. And she makes a few points, and you got to remember these points, because I'll tell you right now, don't think this thing is over. This has a very good shot of going to the United States Supreme Court. The first thing that Judge Sykes says is that Title VII's use of the word sex back in 1964, when Title VII was passed, and now, refers to somebody being biologically a male or female. It doesn't refer to sexual orientation. That's her interpretation. She also says, look, if you look it up in the dictionary and if you look at the ordinary meaning of the word sex back in 1964 and today, you don't use the terms sexual orientation and sex interchangeably. One means one thing and one means something completely different. That's her interpretation. So she sort of went to Webster's dictionary and made a case. She then, of course, went on some precedent, and she listed a long list of federal and state statutes that distinguish specifically between sex discrimination and sexual orientation. And she has a point there, because there are a lot of laws that draw a distinction between sex and sexual orientation. But that's not the case of Title VII. So this is going to be very, very interesting. And Judge Sykes brings up one more very interesting point here. She says it can be very confusing if we use the term sex interchangeably with sexual orientation. Because she then points out a scenario. She says, if the facts show that Ivy Technical College hired heterosexuals for these 6 full-time positions, and then the community college could still be found liable for sex discrimination if it turns out that there were no homosexuals, even though all 6 of the positions were filled by women. Try to explain that to a jury. Understand what she's saying. Sexual orientation could become its own protected class that you would have to basically qualify for. So just because you hired all women for a position, you could still get hit with a sex discrimination claim if you had a homosexual out there that wasn't included. So makes things pretty confusing, doesn't it? So, sports fans, where does that leave us now? Well, I gave you a little map here, and if you are in the 7th Circuit Court of Appeals, Indiana, Illinois, Wisconsin, that is the law of the land. That is what you got right now. So right now, yeah, that is law. I mean, this is different from the EEOC, which is just an administrative agency. They just come out and they say, hey, sexual orientation is now protected. They don't have any real authority. Now, a judge, oh, believe me, particularly a circuit court judge, when they say that is law, it's law. So if you're in any of these other circuits, Title VII does not necessarily apply to sexual orientation, but it does in the 7th right now. So right away we got a split of authority going on. But I will tell you, don't think for a minute that that is over. Well, I'll tell you, there's lots of law going on out there, and I would invite you to go to scottwarrick.com, look at the law college videos that I put together. I'm starting a little law program here. The first 4 up to bat on the ADA, the FMLA, illegal harassment under Title VII, and of course the Fair Labor Standards Act. All right, these are on a flash drive. Put them on your laptop. You can put them in your drives wherever you go, into the TV. You can put them in your intranet to train yourself. They are complete law college courses for HR people and attorneys. They're approved for HRCI, SHRM's recertification credit, and Ohio CLE. So I would invite you to check those out. Well, thank you for listening. I am Scott Warrick. For more information on me and my programs, go to scottwarrick.com. And if you hit on the far left button, it is Speaking and Training, you'll see all the different types of programs that I do and I bring on site. Enjoy your day.